They told you a living trust was a magic shield, that once you signed those papers, your assets were safe, untouchable, lawsuit-proof. But what if I told you that's a myth? In fact, your living trust may give you less protection than you think, and in some cases, none at all. I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've been in the asset protection field for 34 years, and for nearly 30 of those, I've set up Cook Islands trusts more than any firm in the world. And today, I'm going to show you why a living trust is not the fortress you thought it was, and what the wealthy do instead. Before we dive in, hit that subscribe button. I post weekly videos with the truth about protecting your wealth, and I don't sugarcoat it. Living trusts are everywhere. They're sold as the set it and forget it solution. Estate planners, financial advisors, even TV commercials tell you, avoid probate, make inheritance easy, protect your family. And we set up living trust and asset protection trusts for people all over the world. And let's be clear, there are benefits to living trusts. A living trust keeps your estate out of probate court when you pass. It lets your heirs skip the delays, the fees, the public process. It can help with privacy because unlike a will, it's not filed with the court. Sounds pretty good, right? But here's the bait and switch. Avoiding probate is not the same as asset protection. A living trust is about death planning. Asset protection is about lawsuit survival. Those are two completely different battles. A living trust is like a minivan. It carries your family comfortably through estate transfer. Asset protection is a tank. It shields your wealth when the lawsuits start firing. Now, both are vehicles, but each provide a totally different level of defense. Here's a cliffhanger for you. What happens when your living trust meets a hungry plaintiff's attorney? Stick around because I'll walk you through a real-world case in just a few minutes. Okay, reality check. What a living trust doesn't do. So here's the cold, hard truth. A living trust is not a shield, it's a paper bag. Why? Because it's revocable. That means you, the grantor, can change it, cancel it, move assets in and out whenever you want. And if you can reach into the trust, so can your creditors. Case in point, in U.S. versus Eversoft, a tax case, the IRS went after a man's assets inside of his living trust. So guess what? The court said, if you control it, we can reach it. Game over. Or take divorce. If you think putting your assets into a living trust keeps them safe from your spouse's attorney, think again. Courts regularly treat those assets as yours, plain and simple. Here's the key takeaway. If it's revocable, it's vulnerable, period. So why do millions of people still believe living trusts are bulletproof? Simple. Marketing. Estate planners want to make the process sound attractive and simple. Avoid probate sells. Your assets are protected sounds even better. And when people hear trust, they automatically think of powerful, rock-solid structures like the Rockefeller Trust. But let me be clear, there's a massive difference between a revocable living trust and an asset protection trust. One is a paper tiger, and the other is a legal fortress. So it's like comparing a bicycle lock to Fort Knox. One keeps casual thieves away, and the other keeps out armies. Okay, let me walk you through a few examples. Scenario one, the business lawsuit. You own a chain of restaurants, and one day a customer slips and falls. Lawsuit incoming. The attorney does an asset search. They see your house, your investments. Oh, look, title in the name of your living trust. Jackpot. They go after it all. Scenario number two, the car accident. Your teenager borrows the car, causes a major accident. Insurance covers part, but not all. The injured party sues. Same deal. Your trust doesn't stop them. Scenario number three, the divorce. You thought the living trust would make your spouse's attorney back off. Wrong. Courts view the living trust as marital property if you acquired it during the marriage. Bottom line, if you thought your trust was a bulletproof vest, think again. It's more like wearing a t-shirt to a gunfight. And we're not saying that living trusts are bad. They're really good. They have their place, but they're not for asset protection. So if a living trust doesn't cut it for asset protection, what does? So now we get into the real tools. First of all, irrevocable trusts. Once you move assets in, you give up control because you no longer own them. Creditors can't just grab them. The downside, loss of flexibility. The upside, real protection. Next, LLCs. With the LLC, if it's properly structured, it can protect business and real estate from personal creditors and vice versa. The charging order protection remedy in strong states like Wyoming or Delaware means creditors can't seize the company or the assets inside, only the distributions. Next is equity stripping. This is where we place liens or mortgages against properties for our clients so the equity looks tapped out. If a creditor's attorney sees no equity, they're less likely to chase it. And then there's the king of the hill. We have the offshore asset protection trust. We often use a Cook Islands trust down south of Hawaii, part of New Zealand, with a Cook Islands LLC inside of it. Now here's how it works. Here's the trust, this purple box. Here's the LLC inside of it, this light blue box. And you are the manager when the seas are calm. When a lawsuit hits you, our licensed bonded Cook Islands Trustee Company law firm steps in and they become LLC manager temporarily to protect your assets. Since U.S. courts don't have jurisdiction there, the creditors hit a wall. And that's why we've set up more Cook Islands trusts than any firm in the world. And that's why the wealthy clients all over the world call us. Okay, now let me pause here and say this. I understand why people buy into the living trust myth. It's easy, it's neat, it feels like one document will solve everything. The truth, real protection takes layers. It takes planning. And yes, it takes giving up some control. They may be uncomfortable, but it's a lot more uncomfortable to lose everything that you own. Here's the flip side. The peace of mind is worth it. My clients often tell me, business guy, once I set this up, I finally slept at night. And that's the trade-off, control for security. Okay, so is a living trust worthless? No, like we said before, not at all. It has its place. Here's what a living trust is good for: avoiding probate and keeping your heirs out of court. Providing privacy so your assets aren't listed publicly. When my mother passed away on Christmas Day, 2023, I set up a living trust for her. So it made it quite easy for my sister and I to transfer her estate from her name over to the heirs, to me and my sister. So it made things a lot easier. We didn't have to hire lawyers, didn't have to go to court. It made things very, very smooth. Another benefit is giving you control during incapacity. If you're in a coma, your successor trustee can step in seamlessly. So those are real benefits. But here's the key: don't mistake probate avoidance for lawsuit protection. If you truly want to shield your assets, you combine a living trust with stronger tools, LLCs, irrevocable trusts, offshore structures. Think of it like a toolbox. The living trust is a screwdriver, useful, but not a jackhammer. Okay, here's a case study. The doctor who thought he was safe. Now, one of our clients, a doctor in California, we'll call him Dr. M. He had millions in real estate and living trust. He thought he was safe. Then came a malpractice lawsuit. The plaintiff's attorney didn't blink. They went straight after the properties. Living trust didn't matter. Those properties were exposed. Now, Dr. M came to us mid-litigation. We couldn't use the trust retroactively. It was too late because his opponent had recorded Liz Pendence's liens against all of his properties to freeze them during the lawsuit. But what we could do is set up a Cook Islands trust for future protection, and today his new wealth is safe. The lesson? Asset protection is like insurance. It's best to set it up before the fire. So here's the bottom line. A living trust avoids probate. Good. But it doesn't provide asset protection from lawsuits at all. Real protection means irrevocable trusts, LLCs, equity stripping, and offshore tools. Don't fall for the myth. Don't believe the hype. A trust is not a trust. A living trust is not an asset protection trust. So if you want real protection, talk to professionals who've done this for decades. At Asset Protection Planners and Lawyers Limited, our firm, we've set up more Cook Islands trusts than anyone in the world. We know how to structure them so that you stay in control until it matters. When the storm hits, you're protected.